Good morning. I'm Tom Spiggle with the Spiggle Law Firm, where we represent folks who've been fired or afraid that they might be. We represent people in the DC metro area and in the Commonwealth of Virginia. I'm thrilled today to be welcomed by Samantha Vanderpool Rucker, who is an attorney in our office. And Samantha, what are we going to talk to for our folks today?
Let's talk about mediation. Well,
Let's
there's
do
an
it.
adage in real estate that says location, location, location. But in employment law, my thing is mediation, mediation, mediation. And the thing is, a lot of employees are not aware of the benefits of mediation. They think about, I'm upset with my employer, they terminated me, let's sue them. But why not try mediation? And the benefits of mediation, unlike a trial, I tell my clients, for instance, I have a client that's pending right now. He said, what's mediation? I said, mediation is better than trial. It's cheaper than going to trial. And there's less involved in terms of gathering witnesses, documents, etc. Mediation, unlike trial and arbitration, is that it's voluntary, it's confidential, and it's binding, which means that, let's say, for instance, your employer owes you $10,000 in back wages. Go to mediation, you sit down, it's confidential, the mediator is impartial, and he takes notes and he sort of pushes the parties towards an agreement. And once that agreement is reached, that agreement becomes enforceable, meaning that that employer has to pay you that $10,000, even if later on, 2 months later, you said, you know what, I didn't want to agree to that $10,000, maybe $5,000 is better. So you can take that agreement, take it to court, and have the employer pay up in terms of what he owes you. But my thing is mediation, and we should try that first before we try a lawsuit or anything like that.
Yeah, no, it's a great point, and this is, I mean, we could talk for an hour more about this. So well, let's pack as much in 5 minutes as we can. Um, they're all different like forums you can mediate in, right? You've got, mediation at the EEOC, you've got court ordered mediation, you've got private mediation, and all of them follow similar sorts of, the way that they go about it. Obviously, private mediation, you get the most robust, right? You get like former judges or seasoned practitioners, and they're paid to try to come to a resolution. And I think that's an important thing for folks to remember too. Is that can be a great option, even if other mediation fails, through the EEOC or otherwise. Private mediation, even if you have to pay as a client for a portion of that, can be well worth it. Because to your point, Samantha, if you're, maybe you have to pay $5,000, let's say, that's on the high end for a mediator, and he can get or she can get the case done in a way that's acceptable to you versus paying $100,000 or more to take a case to trial and risk losing. Another thing about this, and I'm sure you've probably faced it, is like it's important, and this is part of kind of our legal leverage process and what we do in the firm is making sure you have a game plan when you go into mediation, right? It's almost like a mini trial, and knowing, you don't want to be at that mediation table the first time you've ever thought about, well, what's my number and what are the kind of the non-monetary issues that are important to me.
And I always tell clients, get an attorney. Of course, mediation, you don't have to have an attorney, but you're in the best position to have an attorney. And I guarantee you 9 out of 10 times the employer will have an attorney there. So mediate, and get an attorney.
Absolutely, that's a great point. It makes a lot of sense, and we see people handle their own cases, handle them pro se, and file with the EEOC, and that's great. I mean, I think that's a good tactic to use. But you're right. Once you come up to mediation, you don't have to hire an attorney for the long haul of your case if you don't want. You can hire an attorney just to help represent you in mediation, to get that ball across into the end zone. And just, as you know, Samantha, there's just so many things that unless you're a lawyer, it's not impossible to settle a case if you're not a lawyer. But there's a lot of things that come up just in the fine print of the settlement agreement. Like, what are you? Yes, there's the money piece, which I think most people, have a good sense of that. But like, are you going to agree to a non-compete? Are you going to agree to a non-rehire? Was there a non-disparagement provision? Like, does that apply to you and the employer? There are all these, right? Everybody gets to the number, and then you get the agreement sometimes, and people are like, wait a minute, I have to sign this. So it really does help to have an attorney, talk to them a little bit beforehand, figure out what your number is, get a sense of like what sort of monetary things are you interested in, what the employer might be interested in, what are you willing to give on, what are you not. Because, I mean, you know how it is, those long mediations, like if it's 11 o'clock at night and like everybody's tired, right? And like that's the worst time to be trying to make those decisions. You want to have some idea of kind of what your game plan is going in.
Exactly. I had one case, for instance, where we went to mediation, and after the I's were dotted, the T's were crossed, they got the monetary amount that they wanted, but they wanted to sort of disparage the employer on a website. And I said, no, we can't do that. We just signed sent,
Right.
an agreement, and we can't do that anymore.
Yeah, no, absolutely. Well, Samantha, this has been great. Like I said, we could have gone on for an hour about this, but we'll leave it with folks for about 5 minutes. I appreciate your time this morning, and we'll let you get back to the next thing on your desk.
Thank you, Tom.
All right, bye,
Bye
Samantha.
bye.